B 144-986A and B. And I also have 2B 141-576B. Sir, your name? You have to unmute the bottom left-hand corner of your screen. Your appearance?
Yeah, to your own behalf, Mr. Duff.
John Mark Duff, Your Honor. Can you hear me?
I can't. So we have a possession of a controlled substance charge. It does not appear as though he was ever sentenced on it.
Correct, March.
Of 24. And then I also have here driving on a suspended and unregistered vehicle. He's pleading on the suspend charge with the unregistered vehicle to be dismissed, correct?
Correct, Judge.
Is that what you want to do, sir?
Yes, Your Honor.
You plead guilty on the suspend charge. The possible penalties are up to $500 in fines, 93 days jail costs, or all of those penalties 2 points.
Yes, Your Honor.
Your vehicle could be or might have to be immobilized depending upon your record. And if you plead to that, I'm going to go ahead and dismiss the driving with an unregistered vehicle on motion of the prosecutor. Do you understand that?
I do, Your Honor.
All right. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes, sir.
All right. To the charge of driving on a suspended license. How do you plead?
Guilty, Your Honor.
Operating a motor vehicle in Brownstown Township on March 23 of 24 on Townsend near Donnelly at 5:21 p.m.
Yes,
Sir.
Yes, sir. Yes, I was, Your Honor.
Was your license suspended?
Yes, it was.
Are you on probation or parole right now?
Yes, I'm on probation.
Were you on probation back in March of 24?
Yes, I believe I was.
If you plead guilty here, if you were on probation on March 23 of 24, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. Do you understand that?
I understand that, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
But he forced you to plead guilty or promised anything to induce you to plead guilty?
No.
I'll accept your plea. Driving on a suspended. I'm going to go ahead and dismiss the driving an unregistered vehicle. I'll address the other charge momentarily on the drug paraphernalia that he was never sentenced on. Oh, what's he in custody for right now?
Judge, unfortunately, he is in custody for a felony probation violation. It looks like he had a resisting and obstructing charge. That's before Judge Ramsey. His next hearing date is July 19th. 2025. He indicated that the court is waiting to see what happens in this case. So then I guess he'd be sentenced on his probation violation.
Wait a minute, say that again?
So Judge Ramsey, and he can correct me if I'm wrong, I believe Judge Ramsey is waiting to see what happens on this case. I'm not.
On the driving on a suspended?
Right, because this is 2024.
No, the possession, Your Honor.
Oh, the possession. So the possession that he still needs to be sentenced on, which we don't have a PSI for.
Because he didn't show up.
Right. But I don't know is when were you sentenced to probation for the felony?
I don't remember exactly. I'm sorry.
So I think that
it was before the case before Your Honor.
Oh, well, that might be why she's waiting, because that's the violation.
All right, good enough. Oh, the drug paraphernalia charge was the violation?
I believe so.
All right, let's sentence him on this and then we'll address the possession of drug paraphernalia. What do you want to say? Anything?
Well, he's in custody, so in order to find some cause, I would ask that the court would take that into consideration. He's gonna have bigger issues with the felony probation violation.
It's predictable though, you know, he doesn't think he has to show up. Anything you want to say, Mr. Duff?
I have no excuses, Your Honor. I have nothing to say.
Lisa, were those cash bonds on both of these? On the suspend charge?
10% bonds.
Okay, so I got 3,000, 10%, and I got 2,000, 10% on the other. So he has $450 to apply. 100 fines, 225 costs, 75 victim's rights fee, $50 justice assessment, 450 or 93 days on the suspend. The unregistered vehicle was dismissed. Those are in his name, Lisa. You can go ahead and apply the bonds and close those out. Now, well, I gotta have a PS screening to do this right. I don't even know what kind of drug paraphernalia it was. I mean, it's been going on for 3 years. But he doesn't have a bond on these. And you're telling me your next court date with Judge Ramsey is July the 9th? 19th.
19th, I believe, Your Honor.
Let me just check something real quick.
July 19th is a Saturday.
Okay, it might be the 9th. I'm sorry. I don't have any of my paperwork in front of me.
I don't have a report. Oh. What kind of drug paraphernalia did you have? You've already been convicted. You pled guilty. What kind of drug paraphernalia did you have?
Opioids, Your Honor. Opioids. Opiates.
So maybe it was reduced.
Well, the original charge was, oh no, this was not drug paraphernalia. He was charged with drug paraphernalia and use, and the drug paraphernalia was dismissed, it looks like. Well, screening and assessment. Maybe we can get probation on there to do it today. I can do this in the next week or so. Personal bond, $1,000. And why don't we do this when Ms. Patillo is here, and let's get probation. Call over to probation. Will you please tell them I'd like them to screen and assess Mr. Duff before the county takes him. So let's do that. Please give me a date in about a week, $1,000 personal bond. The other two are taken care of. I'll look at it good. I can sentence before Judge Ramsey does.
Doesn't look like she's here next week. Is it okay if we do like a Tuesday probation day, or do you want it with?
Oh, that's fine. That's fine.
Okay, June 24th at 8:30.
June 24th at 8:30 will be your next court date.
Okay.
Okay?
Yes, sir.
All right. Thank you. Good luck.
Thank you, sir.
Thanks. Mathis. Robert Stephen Mathis, 23B1425991A and B.
Right to the podium.
All right, go ahead. Your appearance.
Robert Matthews.
All right, so this can be a plea to suspended drug paraphernalia to be dismissed, right?
Correct.
Is that what you want to do, sir?
Yes, sir.
If you plead here, the possible penalties are up to 500 fines, 23 days jail costs, or all those. 2 points. Do you understand that?
Yes.
All right. What kind of drug paraphernalia did he have, counsel? Can you tell me?
All
All right. Did you sign an advice of rights and read and understand the rights?
Yes.
Today, I'm asking in conjunction with this plea.
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
To the charge to drive while suspended, how do you plead?
Guilty.
Were you operating a motor vehicle on October 19 of 23 at 4:02 in the morning on Western or Telegraph in Brownstown?
Yes, sir.
Was your license suspended?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
You're another one though. Where you been?
Your Honor, he had some family issues, some personal issues, health issues, some living issues. He apologizes to the court for his absence during this time, but he did have some issues.
All right, I'm gonna accept that plea, dismiss the drug paraphernalia. It was a crack pipe, right?
Yes, sir.
You off of that yet?
Pardon me?
Are you staying away from that?
Yes, sir. Yes, sir.
You wouldn't tell me differently though, would you?
Uh,
All
Well,
right,
I-
let's skip it. They gave you this. What do you want to say, Ms. Patillo?
Just the same thing, Judge, he does have some health issues, he doesn't have any solid income right now, but he does side jobs, and he also has a friend in the court, he does side jobs for her and helps her out, so when ordering those fines and costs, I would ask if the court can set a payment plan, and just take his indigency into account.
100 fines. I'm sorry, did I let you finish? Anything you'd like to say? 100 fines, 250 costs, 75 victims' rights, $50 justice assessment. 475 or 93 days. You pay 50 a week. I'll start this beginning on June the 27th. That's next Friday. Can you do that?
yes, sir.
If you need more time, call the court. We'll go on Zoom. I'll be glad to give you an extension on or before the due date, or you can walk in here on or before any due date if you don't have the money, and be glad to give you an extension, all right? Best of luck. Thanks. Gillingham. Jordan Greg, and I'm sorry you had to wait so long, Mr. Mathis. I really am. Jordan Gregory Gillingham, 25B148459A and B.
Dion Patillo on behalf of Mr. Gillingham, please state your full name for the court.
Jordan Gregory
He
Gillingham.
stands mute, waives formal reading on these.
Yes, sir.
They're gonna dismiss the no ops. He's gonna plead to no insurance, right?
Yes, Your Honor.
Is that what you want to do, sir?
Yes.
To that charge of no proof of insurance, responsible or not responsible?
Responsible.
Plea is accepted. The no ops is dismissed. Fines cost of $185. You can pay that now?
So, Your Honor, he only receives social security, so I would just ask that the court would send him up. He did not bring anything to pay today.
How much can you pay per month, sir?
100.
All right, that's fine. How about starting July the 7th? Can you do that?
Yes.
100 per month, beginning July 7th. You heard what I just told that last gentleman?
Yeah.
If you don't have the money, you come talk to me, okay?
Gotcha.
Be glad to give you an extension. Just don't ignore me.
Gotcha.
Good luck. Dylan Hall. Dylan James Hall. 25B148235A and B.
Dion Patillo on behalf of Mr. Hall, state your full name.
So he's going to plead the possession of a controlled substance. He's going to plead the possession of a concealed weapon. That'll be under 70, true?
Correct, Judge.
Is that what you want to do?
Yes, sir.
If you plead here under 7411 or under HIDA, the possible penalties on these are up to 500 fines, 90 days jail, costs for all those. That's on both charges under local ordinance. And I'll take those under that statute. I'll defer the proceedings, set terms and conditions. If you're compliant at the end of the specified period of probation that I set, this case will be dismissed. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, to the charge, possession of a controlled substance, how do you plead? To the charge, possession of a concealed weapon, how do you plead? On April 28 at 25 at 12:15 in the morning, were you operating a motor vehicle, or in a motor vehicle, I should say, on Telegraph near Dixon, Brownstown?
Yes, sir.
Were you in possession of a controlled substance?
Yes, sir.
What were you in possession of?
Marijuana.
He wasn't, okay, were you in possession of a concealed weapon?
Yes, sir.
What kind of weapon was that?
Pistol?
Well, I mean, I don't know, I wasn't there. Were you in possession of a pistol that was
It was
concealed?
in a lockbox, Judge, inside of the vehicle. It was
Oh.
his father's vehicle.
And he didn't have a CPL or anything, right?
No, he did not.
Okay. Okay, I see, he's less than 21. That's why. All right, are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Okay, so that's why the marijuana charge, please accepted. I'll defer the proceeding under section 7411. I'll also, on the drug charge, and I'll also defer the proceeding under HIDA on the concealed weapon charge. I'm going to order a screening and assessment. You're going to be screened and assessed today, and then you'll come back for sentencing at a later time, okay?
Yes, sir.
Let me just check one thing. I want to. So this was. Okay, So I already said a bond. No marijuana, no alcohol, no illegal drugs, no firearms or dangerous weapons. Screening and assessment you'll undergo today. What do you have, Lisa?
July 16th at 8:30.
July 16th at 8:30 will be your sentence date, okay? What are you doing? Are you in school or graduated?
Just graduated last month.
All right, so what are you gonna do?
Just working.
He
Where?
works full-time with his father right now.
Well, that's good. All right, July 16th at 8:30. Go down the hall, get your notice. And then come back on July 16th. But before that, today, before you leave, you're going to the probation department, okay? Thanks, good luck. Talise Jackson, Talise Noel Jackson, 25B148486B.
Good morning, Judge Dion Patillo on behalf of Ms. Jackson and Fitcher for me.
Talise Noel Jackson.
All right, so this,
Your Honor, I believe she was already sentenced. I think Your Honor just gave her time to pay an extra $400, but she has a $415 bond.
Lisa, I don't have a sentencing,
Looks like she took a plea on May 7th and you set it for sentencing today.
okay, and she never, well, but now they've generated a show cause.
It was actually, you gave her time to pay another $400.
Wait a minute, they've got the wrong show cause in here. What's going on?
Yeah, I don't have that for her.
We have two Jacksons on the docket. Is this Talise?
Yes.
This is
Okay.
Talise, and I have a 19T633606A. I've just got the probation violation show cause. And then I've got 25B148486B, which is from an April 1825 date. So I need the probation file or our court file on,
It's a 2019 case.
exactly.
Right.
That's the one I need the file on, 19T633606A.
Okay, I'll pull that one right now.
Okay. Can you pull that up on the screen here? Yeah, that one. 606A. That one. Can you move all that? There you go. Let me see it. So it looks like 12 months probation. What kind of charge was that? Did I place her on probation?
We did, Judge. We did deal with that last time. I don't fully remember what happened. I want to say, Your Honor, close that probation out.
All right. Well, let's go on and talk about this suspend. Ma'am, your name? Can you see it? 1 second. I just want to make sure I've got everything. This is from 19. I see what happened. I entered a not guilty plea on all of these charges on May the 7th, you're all set. So she gave me the file. I entered a not guilty plea on all these charges. Failure to attend scheduled probation visit on August 9 of 19, failure to pay fines and costs, failure to clear all warrants as directed. So she must have indicated that they did not want to plead and wanted a hearing. Is that what she wants still?
So no, Judge, if I remember correctly, I thought you said we would deal with it all and you gave her time to pay $400. That was the last thing he had. Cause she was asking about her employment and could she pay the $400, and you said, you know, I'm gonna give her time to pay the $400, and I thought
She
that's
posted a bond on April 24th.
right. It should have been $415 or $400.
Did she clear her warrants?
So
No, that's a short way of saying,
her warrants were clear, but she did get something from Secretary of State saying that she would be suspended through what, June 23rd?
because of this other suspend conviction, I bet.
Yes. But she did clear, I believe the majority of that was cleared the last time we were here.
All right, so right now, it looks like she owes somewhere in the neighborhood of $370. Lisa, is that true? No, she owes $455 on that 19 case.
Right.
But she entered a not guilty plea. I don't know what else to tell you. Does she want to plead guilty and I'll go ahead and sentence, or you want to have a hearing?
So that last hearing is on YouTube, Judge. She had pled guilty to all of that. I watched the YouTube video yesterday.
Really?
Yeah, and so.
You're kidding.
It's like-
Okay,
One of my other clients pointed out. So basically what Your Honor was gonna do was just give her time to pay $400 on that probation
she
fund.
already paid that as a bond on April 24th, just so you know.
Right. That was for, I believe, the tickets though. The probation is what Your Honor wanted her to, wanted to give her time to pay that.
I said defendant to save money,
Yep,
clear warrants,
right,
sentence date June 18th.
right. But the warrants on that.
Did she
day-
save money?
Yes, she brought a couple dollars with her.
What's a couple dollars?
So the only issue with that is her payroll is gonna hit sometime today,
Yeah, it's fine.
and she can make that payment.
It's,
So you're telling me she pled guilty?
Yes.
Yeah, I did set sentence date. Okay.
Judge, I have it as pled guilty and clear all warrants, sorry.
And did she clear the warrants?
Yes, Judge, I believe they were cleared that day, it's just she got this notice from Secretary.
She kind of was a little nasty that day, wasn't she?
I
A
was,
She,
very much so,
little disrespectful.
yes, and I apologize for
You
that.
didn't show up for 6 years and I'm the bad guy, right?
so it was a little more than that, Your Honor. Yes, that's what happened. Yes, Judge, but she was very apologetic. She just had a lot of family issues going on back in 2019.
You're right. May I please speak?
There's a
Sure.
couple things that she wants.
I'm gonna sentence you on both of these. I'll give you all day. If you want to tell me whatever you'd like to say, I'll be glad to listen.
Okay, so, for 10 or 11 years, I was in a very toxic relationship. And throughout that, the way that I cope with alcohol and.
I'm sorry, the way you cope is
I cope
alcohol.
with
Okay,
alcohol.
okay.
Became an alcoholic, throughout those years. My last straw in that relationship was when I had to testify in front of you, when my son's dad, choked me when I was pregnant with my son. After that, I left and I went to rehab. That was in 2020. So in February 2020, I went to rehab. And then I graduated from rehab. And then I lived in a shelter with my children to be safe. And after that, I came back down to Brownstown, got a home down here. I moved here, and I got a job at Kroger. Every job that I had after that was a better job. I got a job at Kroger, the Oakwood Group. I worked at Amazon, and then finally now I'm at Ford. Now I work there. I bought my home. I paid my tickets. I bought my first car in my own name. So I really, like after you go through rehab, it's not like you just jump back into life. You have to learn to become normal. Like you have to learn to live in society as a normal citizen. You have to learn to cope with things. And alcohol wasn't my problem, it was my solution. It was a way to deal with the things that I was going through. I didn't understand that until I took up counseling and therapy. So through that, that's what I've been doing over these years. I haven't been like, I live a very peaceful life. I go to work every day, I take care of my children. And I guess because I felt like I had accomplished so much in that, I kind of let this stuff fall to the wayside. I didn't care about these tickets and stuff back then because I was in active addiction. It's hard to care about those things when you're like that. So when I did get clean, my intentions were to get all of my business and stuff taken care of. So I did go and I paid a lot of money to the Secretary of State to go and get my tickets and stuff cleared. You know, I was taking care of everything. I got a valid license, and I was proud of myself. And I thought I had done everything to be in good standings with the court system, and I wasn't. So when I came here, I was a little bit frustrated because of how I was came down on. When I don't know, I guess I was just, I felt so accomplished. And then I came here and I was just like you're just like, you did nothing. And I did. Like, if I were on probation, I feel like they would have put me in rehab and they would have did those things. And I did those steps on my own. And I watched the compassion you had for the people that came in here prior to me, where you had someone here and you said they were in the parking lot doing shooters and they had every drug in their system under the sun. I don't have any drug convictions.
All right, okay, so.
I'm just saying, the extent of my background.
I came down on you because you hadn't been here in 6 years, and I hate that.
And I understand.
That shows such disrespect. Shows incredible disrespect. That being said, I give you a lot of credit for getting along here and doing well. Good for you. And now I'm going to go light on it. All I need is people to tell me I made a mistake, I screwed up a little bit, and not start fighting with me when I tell them how wrong it is for somebody not to have been here for the last 2,000 days. You get what I'm saying?
I do understand where you're coming from, Your Honor. I thought that I had taken care of what was supposed to be taken care of. That was my intentions. My intentions were
fair enough. Fair enough.
So that's where I'm coming from. I really wish you would consider my
intentions. I'm gonna be fair with you.
Actions.
I'm gonna be fair with you. Really? Okay. I give you a lot of credit.
Thank you. I appreciate it.
All right, here's what we're gonna do. She's got a 400, Lisa, is that 4,010% on the 3606A file?
Yes, it is.
All right. Good enough. I'll tell you what. You pay $360 on that case, which consists of your bond. By law, we keep 10%. So you're going to sign over the bond, and that case is closed. Okay? Then on the other one, 100 fines, 175 costs, 75 victims' rights, $50 justice assessment, 400 or 90 days. Okay?
Thank you so much.
And how much does she have today? She's got, we're not that bad here. Okay?
Okay.
How much did you say she has?
I have about 500 today.
Well, then you can pay this 400, sign over your bond on the other, and you're gonna walk out with 100. Oh, wait, I do have to have the stop sign case, right? There's an A file there. Was it?
Was it?
Let me just check.
That one was set for sentencing today also.
All right, I'll tell you what. Fines costs of $100. I'll cut those down for you. Okay?
Thank you, John.
Good luck to you.
I apologize again for last time.
No problem.
Thank you.
Good luck. Thank you. All right. Do you have any others for me, or am I going on to the civil infraction?
Caleb felt it. Oh, I see here in file, but I'll come back.
Okay, good. All right, let's go on, Township of Roseal versus Alicia Strong, 25I-76086. Mr. Lechner?
Afternoon, Your Honor, Attorney David Leck, number 67994 on behalf of Alicia Strong, stands to my right.
Ma'am, your name?
Alicia Strong.
Mr.
Morning,
Money?
Your Honor. Lisa Hamami on behalf of Roseal Township.
All right, so today is the date scheduled for formal hearing. As you pointed out in your briefs, each of you filed briefs. We did go out, the three of us, to a site visit at the Strong residence. And then I asked the two of you to submit briefs, and they were very good, by the way, both of them, I thought, really good. So I read the briefs, and we're going to proceed with the hearing. And we can start, and you could just tell me if you have any preliminary matters, and if not, then you can go ahead and give your opening statement.
We have one.
We have a couple of preliminary.
Okay, go ahead.
I have a picture of that when I introduced into evidence, Mr. Mames objected to it because my clients did not take the picture. The picture was procured through discovery of a civil matter. It's taken of the trampoline from the neighbor who complained about the trampoline. And it's,
Well, they don't need to take the picture. They just need to show that it's an accurate depiction as to how it looked on the date of the offense.
That's the issue, Judge. This predates the installation of the trees. This is several years prior to the violation being issued. Whereas the photo that we're submitting is when that violation happened.
Well, let's just take it one step at a time. We don't need to decide that right now. You're going to put in your case. You can make your opening statement if you choose to. And then Mr. Lechner can, we'll go through the proofs and I'll rule as the objections come up. Okay?
understood.
There are a couple other matters, Judge,
Okay.
quickly. First of all, my brief, I articulated that there were two violations that Alicia Strong was facing. One was in relation to a fence and the other was in relation to the trampoline. At the time I wrote the brief, and actually up until today, it was my understanding that they were admitting responsibility on the fence and that was not going to be an issue that we needed to address at a formal hearing. I understand today that that is not the case, so now we're going to have to take testimony on the fence. And I wanted to alert the court because that is not what was in my brief and that wasn't my understanding.
Is the fence going to be removed?
If my clients are found responsible for the violation, they will remove the fence. They're not looking to remove the fence of their own volition prior to that.
All right. Okay, so we'll proceed on both charges. That's fine. So I'm going to need, they didn't really, did we set up a file on this other one, Lisa? In other words, they checked the waterfront provision, count one. They didn't check count two.
They're both under the waterfront provision. The waterfront provision, the waterfront.
I know, but they still, if they're charging two separate acts. Lisa, do we have a file set up on count two?
No, we only entered a count one zoning violation.
Because there was no count two indicated on here. There was no check of the civil infraction box. So you have to remember you do that, whoever's filling these out.
We can certainly write another ticket and start all over, Judge.
We might as well.
I mean, I think we've all operated, Judge, to be fair.
I didn't know. I only knew that there was the one count pertaining to the clear triangle. But that's all I knew. And until I read your brief and you said that they were taking it down and you didn't need to address it. So I'll do whatever you want. If you want, do you have you can issue another citation right now, I suppose.
Well, I can move to add it as a count here if the court would allow it, since at least defense counsel and I have operated under the assumption that it was included.
It's just a case count is all it is.
I can add a count.
Yeah, so let's do that.
Is it the same charge, zoning?
It's under chapter 103, 2 white panel fencing near canal.
It's actually under the same 285 Article 17.
Okay.
Okay, I'll make a file right now.
It says 103.
Right.
So now I'm going to object because does the township know what they're writing tickets for, or do they not know what they're writing tickets for? Because one of the tickets not box isn't marked. Yes, Ms. Mami and I discussed it, but we also discussed prior that 103 doesn't apply here because they don't meet the geographic standard under 103, and the ticket says 103.
Whatever you guys want to do. I'll be glad to address just the first civil infraction, Ms. Hamami, and you can issue another one onto the fencing.
That's fine, Judge. We will write another ticket.
So
This
we'll
is
ju-
also a permit issue.
So we're just going to proceed under count one.
That's fine, Judge.
All right, any other preliminary matters? Mr. Lecter?
No, Your
Ms. Hamami?
Yes, Judge, I understand that defense counsel intends to call a witness that I don't believe has any bearing on this case, so I will be objecting as to relevance.
Who is it?
His name is Tom Metcalf. I informed Mr. Mami that we might be calling him. I haven't made up my mind whether to call him yet or not. He's a neighbor on the other side and does have a view of the trampoline. His testimony would be to whether or not the trampoline obscures vision.
Okay.
But the clear vision triangle is established for the purpose of both adjacent neighbors. He's not within that. And the location of the clear vision triangle is based on measurement of just the two adjacent.
Right, so we'll address that as we go as well. Do you wish to give an opening?
No, Judge, we'll waive our open.
Do you wish to give an opening?
No, Your Honor.
Call your first witness.
Your Honor, this time the people will call Ross Quera to the stand.
Right to the
Witness chair up here, sir. Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God? Is your last name B-L-A-I-R?
No.
Okay.
Quero.
Oh, I thought you said Blair.
Yeah, no, it just kind of
Spell the last name.
Querro.
Quero.
Yes, sir.
Okay, you may proceed.
Mr. Quero, what is your present occupation?
Community Development Director and DDA Director.
In Grosedale Township?
Roseland Township.
And to get that position, did you have any education or training?
Yep, a bachelor's degree in public affairs, master's degree in urban planning, and a certificate as an American Institute of Certified Planner.
And what are your job duties presently?
Overseeing development on the island, residential and commercial development, overseeing code enforcement, overseeing downtown development.
So you're familiar with the zoning ordinance?
Yes,
You said you had a master's in, what was it?
urban planning.
All right, so let's talk about Grosedale Township Code, section 285.17. Do you know what that section is?
Waterfront provisions.
What is the purpose of these provisions, these regulations?
It's to regulate waterfront property. The specific zoning ordinance that we're discussing today is maintaining waterfront views.
Yeah, let's talk about the specific 17-4D.
Yeah.
You familiar with that provision? It's the clear vision triangle provision. Can you describe to us what is a clear vision triangle and what is the purpose and how is it calculated?
Yeah, so the clear vision triangle is essentially a 30-degree triangle from the average shoreline setback. That average shoreline setback is established by taking a calculation of the subject property, the two adjoining properties, and the other adjoining properties to that. So it's a total of 5 properties that we basically measure from the shoreline to the principal structure, and we apply that average to the subject property.
So a clear vision triangle calculation will vary from property to property.
Correct.
What might be at the distance for one property, the very next door might be different because it's calculated based on the two on either side.
Correct.
Okay. And do you, historically, let's talk about the application of section 285-174D. Now, this is the clear vision triangle section. And has this section in application been limited in any way to landscaping, trees, or shrubs?
Yes.
It has been limited to that?
Could you clarify what you mean by limited to that?
Is the only thing that cannot be located in the clear vision triangle landscaping?
No. Thank you for clarifying. No, we typically ask that all residents don't place anything within the clear vision triangle. Whether that be a playground set, a trampoline in this case, or landscaping as well. And we define, we have strict regulations on the landscaping element of the clear vision
That
triangle.
go a little bit further than the other stuff.
Correct.
Have you or your department ever had to take enforcement action for the placement of the playscapes or trampolines within a specific clear vision triangle?
No.
Why not?
It's typically well understood that People take a lot of pride in our community about their waterfront views. They have property values that go along with that. So it's well understood that, hey, let's not put anything in these clear vision triangles so we all like the view of the water. So just sort of a warning, like, hey, could you, maybe we've sent a notice perhaps, but it's never elevated to a ticket or anything extreme.
So you wouldn't be surprised if a notice went to somebody that they have a playscape or something in the clear vision triangle?
I would not be surprised.
And may not have reached any further because they moved it at that point.
Yes.
All right, let's talk about specific property, 28658 Barbara Lane, the reason we're here. Are you familiar with that property?
Yes.
How are you so familiar?
I believe on my first week, I became familiar with the property. So we've been dealing with this property for about 3 years now.
And this property is located in Rosedale Township?
Yes.
And how have you been dealing with it for 3 years now?
Countless ordinance violations on both subject properties.
When you say both subject properties, what do you mean?
The neighbor to their north.
Okay,
So
this is a property line dispute as far as you understand?
Correct.
And so the township is involved in enforcement actions against both?
Correct.
Generally, okay. This particular violation, the clear vision triangle, are you familiar with this issue?
Yes.
Okay, can you describe what the issue is?
Yeah, so the subject property owner came to us a while ago, wanted to establish a boundary between themselves and their adjoining neighbor. We said, well, the way that you can create that is by having, there's this clear vision triangle ordinance where you can plant your shrubs. And they did. And, since then,
Well, let's take this step by step so it's clear. So they came to you about wanting to establish some sort of division between the adjacent property owner.
Correct.
And you advised them that they could put trees as long as it's not within the clear vision triangle.
Correct.
And they did install those trees?
Correctly. Yeah, they did it correctly.
Okay, when you say they did it correctly, they actually did it along the lines of the clear vision triangle.
Correct.
And does that essentially depict where the clear vision triangle is?
Correct.
Okay. And your office, in fact, sent several correspondence to the defendant, Alicia Strong, explaining these violations.
Correct.
And it ultimately led to the issuance of a citation, which is the reason we're here,
Yes.
for violations of section 285-17-4D, which is the clear vision triangle.
Correct.
And so the current violation, you've seen it yourself, you've been out to the property.
Yep, so
And tell us what the current violation is.
there is an obstruction of views to the waterfront, by
By what?
the trampoline.
By the placement of a trampoline.
Correct.
And you're certain that the trampoline is located within the clear vision triangle?
Correct.
How?
By the establishment of the arborvitae.
The
The-
tree line
the tree line.
that you say conformed to the ordinance?
Yes.
Okay. You also indicated that it was an obstruction.
Yes.
Why do you say it's an obstruction?
There's visible, it's visibly obstructing the views of the waterfront via the mesh, the posts, the bouncy part of the trampoline. It's structured, there's a structure visibly present.
So I am going to show you what has previously, did we get the exhibits back?
No.
I'm sorry, may I approach? Thank you. I am, Judge, may I approach the witness?
Yes.
I am gonna hand you what's previously been marked People's Exhibit Number 1. Do you recognize that photograph?
I do.
Is that a fair and accurate, it's already been admitted into evidence. Can you describe, looking at that photograph, the trampoline has mesh around it.
Correct.
Is there anything about that that you believe is obstructs?
Yeah, the mesh, the posts that are approximately 9 to 10 feet tall.
I don't think you guys stipulated to the admission.
We did. Oh, we didn't put it on the record. I'm
Okay.
sorry.
Is that true? You stipulate to the admission
Yes.
of People's One?
People's
yes.
1 and 2, defendants 1 and 2. I'm sorry, we should have put that on
That's
the record.
okay. All right. So People's 1 and 2 pursuant to stipulation as well as defense 1 and 2 are admitted. All right, I'm sorry.
No, that's great.
That's all.
And there's no, is there any, what is a trampoline? What's the purpose of a trampoline?
It's to play on, to bounce and jump on.
So if there were kids playing on that, would that, in your opinion, further obstruct use?
Sure, yes.
So I want to talk to you about, I'm going to show them. Judge, may I approach with me? Oh, gosh, that's right. I'm sorry. Judge, I have no further questions for this witness.
Okay. Ms. Cross?
Yeah, thank you, Your Honor. Actually, where I was, I pronounced that right.
Yep, yes, great, thank you.
Do you remember having a telephone conversation with me back in the beginning of April?
I do.
Regarding this specific incident?
Yes.
And at that time, I asked you about the clear vision triangle. That was what we talked about, correct?
Yes.
Okay. And I asked you specifically about the trampoline because that's what the ticket says. And we discussed the language of the clear vision triangle ordinance. Do you remember that?
I don't remember anything mentioned about a trampoline. I remember you were asking me to verify that the Strongs had planted the arborvitaes correctly according to our ordinance.
That was one of our, yes, I asked that. And as you already testified to, the arborvitae was planted correctly.
Correct. Yeah.
And just switching regarding the arborvitae, isn't it true that you reached out to the Strongs in May of 2023 because a complaint was raised before they planted the arborvitae?
Correct.
And you and you calling the Strongs about the arborvitae, you want to see where they were putting it so that they were in compliance with the clear vision triangle.
Correct.
And Mr. Strong came and met with you at your office and showed you where he was putting it, and is that correct?
Correct.
And I know now that the trees are in compliance with clear vision triangle, but did he plant the trees where he said he was going to plant them during that meeting?
Correct.
Okay. So talking about, Ms. Mama asked you, I understand that now. Talking about the clear vision triangle ordinance, specifically 28517.4. There's the first line says each lot shall maintain a clear vision triangle along both sides of the lot lines between average shoreline setback shorelines described below.
Excuse me. Ladies, I wish you could let me in on the humor. I could use a good laugh, but I'm gonna ask you to take it out in the hallway, okay? Thank you. Please. Thank you. Out.
And the next sentence says, within such clear vision triangles, the planting of continuous row of shrubs, evergreen trees, or other vegetation that obscures views along the shoreline shall not be permitted. Is that a factual recitation of the ordinance? So I asked you about the conversation you and I had in April. Do you remember me bringing up that the language of the ordinance saying that there's nothing in the ordinance that precludes trampolines or anything else?
I do not.
Okay. So you don't remember telling me that the township had planned on amending the language of the ordinance to be more inclusive as opposed to less inclusive regarding only green items, trees, shrubs?
I do not.
I asked you, because we were talking about the trees in the conversation, I asked you if you had anything in writing stating that the trees were within the clear vision triangle. Do you remember that question?
Yes.
And you told me you had something, but you didn't know where it was because the file was so voluminous. So
Yeah.
I was to FOIA it.
Yeah.
Okay. I'd like to approach with my approach.
You may.
Handing you what's been marked as defense exhibit number 2, I believe. Do you recognize this document?
I do.
What is it?
This is a write-up that I had in preparation of a meeting with the adjoining neighbor on 3/7/25.
Okay. I direct your attention to the highlighted section with paragraph 5.
What is this marked?
Offense 2. Your Honor.
Okay, which has been admitted.
It has been.
Okay.
I direct your attention to paragraph 5. What is paragraph 5?
It's a complaint from the neighbor stating that the trees is blocking her waterfront view, and I stated that the trees adhere to the 30-degree clear vision triangle.
They were referring to the arborvitaes.
Correct.
Okay. What's paragraph 6?
They stated that the Strongs placed a trampling right on my property line, backyard, also blocking my 180-degree waterfront view.
Okay. What was your answer to that?
I stated civil.
What does that mean?
I stated that that was a civil dispute, so between the property neighbor, but both property owners. But upon inspection of the trampoline, it wasn't on the property line. It was on the subject property's backyard.
Do you know when the
Wait a minute. Repeat that.
So this,
I understand the neighbors from the Strongs are, what is their last name again?
pin,
So the Pins complained that the Strongs trampoline was on their property, on the Pins property.
on the property line.
And then you went out and looked, and did you make a determination as to whether or not the trampoline was on the Strongs?
I did, and it was very clearly on their property.
Okay.
When, after I had this meeting, that.
Then what did you follow up with? The next sentence you said is what I didn't understand.
Oh, I'm not sure if I remember.
Okay, so you went out and looked and verified that the trampoline was on the Strong's property.
Correct,
None of it was on the Pins property.
correct.
And I thought you followed up with something that
Well, and then I made the determination that it wasn't civil because it wasn't on the property line. It was clearly marked on the Strong's property, so therefore it's no longer civil.
what is it now?
It's a zoning violation. It's a violation of the waterfront provisions, the clear vision triangle. Because if it was on their property line, on both property owners' property line, that's a civil matter, right? At least in our view.
So
Well, I agree with that.
to follow up on that, if the Strongs, so just correct me if I'm wrong, if the Strongs put their trampoline over the property line, so it straddled their property line, the Pins property line, it wouldn't violate the clear vision triangle and you wouldn't do anything about it?
Our typical practice is that when there's ever a property line issue, we do not get involved. And that's directed from our township.
This trampoline, if you're aware, I don't know if you're aware of this or not, this trampoline predates the Strong's arborvitae.
Correct.
So when the trampoline was installed in March of 2022, and the Pins complained about it, can I approach, Your Honor?
Yes, with what?
Defense number 1. Handing you what's been marked, who's been admitted as defendant's exhibit number 1. 2023, excuse me, correct, it was 2023.
Right.
What did I just hand you? Do you recognize it?
Yeah, this is emails between Brittany Hoover and Julie Cordes regarding the placement of a trampoline.
Okay. And Julie Cordes emailed Brittany Hoover, is that correct?
Correct.
Julie Cordes is a ordinance officer in the township.
Correct.
And what did Officer Cordes ask?
She asked, I guess to get to the point, does the trampoline need to be in the clear vision triangle?
Okay. So this was raised over 2 years ago.
Correct.
And there was, what was, just for to complete the record, what was Ms. Hoover's response?
I do not believe we regulate playscapes / trampolines, but will forward to Lori for further clarification. She'll be back in the office tomorrow. Thanks.
Okay. And that was on March 28th, 2023?
Correct.
So when Mr. Strong came into your office in May of 2023 to discuss the arborvitae, did you raise the trampoline at that time?
I did not, and what I just clarify here, the number of ordinance violations that were thrown between both properties at that time, we have a small staff.
Sure.
We have a part-time ordinance enforcement officer. At this time, we were dealing with a lot. So, at this time, I think that we just didn't follow up on it. It's very possible.
All right. The ordinance specifically says that the shoreline is not to be obstructed. Is that correct?
I don't have to, well, along those lines, sure.
I approach, Your Honor?
Yes. What is that,
It's
Mark?
a copy of the ordinance.
Okay,
It's not it hasn't been admitted, but
Is it being used to refresh?
yes, being used just to refresh recollection. Could you read that to yourself, please? Let me know when you're done. So the ordinance itself is to not obscure views along the shoreline. Correct. Is that correct? And as you stated, plaintiff's exhibit 1, you can see through the trampoline. Is that, do you have the plaintiff's exhibit 1 with you? Did you take it back home?
I have plaintiffs too.
Plaintiff's 1 is.
Yeah,
I know, yeah, I'm aware of that, and
Okay.
sure that there's the mesh that you can see through, but that still does obscure, in our opinion, the township's opinion, it obscures the waterfront views.
May I approach, Your Honor?
yes.
And you.
Yep.
So you can clearly see the trampoline in plaintiff's 1, is that correct?
Correct.
And you can see what's behind the trampoline, can't you?
Correct.
What's behind the trampoline, Mr. Brown?
A boat.
A boat. Just a boat, or can you see the boat? What's the boat look like?
It's covered in plastic wrap.
Okay. So it's not obstructing vision. You can see through the trampoline to what's behind it. And let me ask you this, how far behind the trampoline is the boat?
I couldn't tell you.
Could you make an approximation? Is it more than 10 feet?
I'd say it's more than 10 feet.
Is it more than 20 feet?
I can, possibly.
Okay. Can you see past the boat to see the canal? Can you see the water?
No. Past the
On
boat is.
not through the boat, but on the
So yeah,
side.
because the trampoline is not obstructing those views, but yes, because those are clear.
No further questions?
Redirect?
Just a couple of quick ones, Judge. I want to get back to this discussion about the civil, your response in that. So let's back up a minute.
Yep.
That document that's been marked Defense Exhibit 2 that was handed to you, where did this come from?
That came from me.
No, the original document. How did this start?
Well, the subject property's neighbor had given me a list of complaints, so I addressed them each individually.
So did they send it to you in Word?
Yes.
So you actually took these questions,
Yep.
and underneath each question, there's a bullet. That's your answer to each of these questions.
Correct.
And do you recall when you got the original email Word document with the questions?
It was sometime before this meeting, I believe about a week, that's me guessing though.
Okay.
But before this meeting.
And do you recall when these bullets were inserted, when you answered these questions?
It was probably the day before,
Day before what?
the meeting on 3/7/25.
So the handwriting on the top of this document, this reflects a meeting?
Correct.
Okay, so you get a list of questions.
Yep.
You respond to those questions with bullets, and then you have a meeting to go over these items with the complainants.
Correct.
Okay, so before you had this meeting and before you visited the property is when you answered these questions.
Correct.
All right. When you indicated in paragraph 6 that it was civil, you've testified that it was because you originally thought it was on the property line.
Correct.
And that's because you are aware of a civil lawsuit between the parties regarding the location of that property line.
Correct.
And when it's an issue of on the property line, you defer to the circuit court,
Correct.
which is why you said civil here.
Correct.
But then you met with the complainants, and then you went out to the property and made your own observations.
Correct.
And when you explained to the judge, and the judge was confused about how you testified, which is why I feel it's important to explain this. When you testified that you went out and you saw, oh, it wasn't on the property line, now it's no longer civil,
Right.
deferring to the circuit court.
Right.
But when you're out there, you see, oh, it's within the clear vision triangle,
Correct.
which is a violation of our zoning ordinance.
Correct.
Okay.
And that was when, sir?
The date of the meeting, which is written on D2, is March 7, 2025. And he went out there subsequent to that meeting.
Correct.
Do you remember about when?
I'm not, to be honest, I'm not sure, but it was after my meeting with her that we went out and we had inspected. And that's when we sent out the
First
the
letter.
notices and notice of violation.
The other thing I wanted to ask you, the title of the ordinance that's been handed to you,
Yes.
285-17-4D, what is it called?
Clear vision triangles.
It doesn't say unobstructed vision triangle, right?
Correct.
And your understanding of the intent of that provision is what?
To maintain clear vision.
And then one last question, People's Exhibit 1, which is the photo of the trampoline.
Yes.
Is there anybody in there?
No.
Nobody's jumping on the trampoline?
Correct.
No further questions.
Any other questions, Mr. Leck?
Yes, Your Honor. Mr. Quero, you testified that there have been numerous complaints between the parties, the neighbors, for the past few years. And the document, the defense exhibit 2 that I asked you about, Ms. Lam, I asked you about, you said you had a meeting with Lisa Pin on March 7th of this year regarding that, correct?
Correct.
But these complaints were sent to you well before that time, weren't they? Didn't Lisa Pin send you an email on November 20th of last year regarding this?
Correct.
Okay, so you only met with her 5 months after, give or take 5 months after, and is it possible that, I'm sorry, I didn't get you to ask the question. So you met with her 4.5 to 5 months after the November 20th email with these complaints?
I don't, so we had email exchanges on prior to 3/7/25. I'm not sure if that went as far back as November.
Well, I mean, you testified that both parties have been filing numerous complaints for the past few years on this.
Yeah.
So isn't it possible that she's made multiple complaints about the same issue?
I'm gonna object, Judge, he's asking, yes.
Any response?
He testified that already that there's been numerous complaints going back and forth. I'm not asking him to guess, I'm asking for him to give us the best answer that he can. If he doesn't know, that's a fine answer, but that's not asking him to guess.
Do you know, sir?
Yeah, there's been numerous complaints over and over again. So, and over the years, I mean, some have precedent over others, and we had to, it's, you know, we're keeping fires out at the, you know, for ordinance violations. And, you know, sure that, you know, your honors here is familiar with our department, and, you know, here, we have a large workload, for the three of us. Some violations fall by the wayside every now and again.
No further questions.
You can step down, sir. I'm gonna take 5 minutes. Thank you. Stay seated. All right, call your next witness. We're back on record.
Judge, at this time, if people would like to call Brittany Bowell.
Let's change this.
Okay, you can come on up here, ma'am. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Can you spell your name for my recorder, your last name?
Buber.
Thank you.
Brittany, what is your occupation?
Permit coordinator.
What does that mean?
I process permits. Building, electrical, mechanical, plumbing.
What does processing permits mean? Describe to me what a day looks like.
Sure. So I take in permits, I review the permit applications. I review the applications for completeness, and then I distribute them accordingly, depending on who needs to review them.
Who is an employee of the township?
Correct. Zoning administrator, building official, engineers. And then once approved, I will then try and process the permit, add any fees that are due, any bonds that are required. Once the permit's been issued, schedule any inspections that are necessary. Once all the inspections are complete, return the bond if there was one, final out the permit.
So I didn't hear you say anything about applying, interpreting the township zoning ordinance. Is that part of your job duties?
It is not.
Have you ever had any training or education in planning and zoning?
No.
Have you ever worked in a planning or zoning administration in Grosse Ile or anywhere?
No.
Judge, may I approach the witness?
You may.
What I'm handing you has been previously marked Defendant's Exhibit Number 1. It was stipulated to by the parties. Do you recognize that document?
I do.
And are you the author of that document?
I am.
Okay. Can you just, we've already heard testimony that the document started with a question from the code enforcement officer to you.
Correct.
And what was that question?
Is this allowed? Does the trampoline need to be clear of the vision triangle?
How did you respond to that?
I do not believe we regulate playscapes, trampolines, but will forward to Lori for further clarification.
Who's Lori?
The zoning administrator at that time.
Okay, and so Lori would be familiar with the zoning ordinance.
Correct.
Okay. Do you have any idea why Julie would have asked you the question?
So at that time, I was the assistant permit coordinator, ordinance assistant, and DPS secretary, so it was common for her to send me questions to try and find the answers to.
And when you said you don't believe that we regulate, what did you mean by that?
We don't require permits for any trampolines or playscapes. Things of that nature do not require a permit. So at that time, I did not know that we would regulate it in accordance with any of the other ordinance, like waterfront provisions, I wasn't really familiar with.
So you were focused on whether a permit was required,
Correct.
and that's why you gave the answer you did?
Correct.
But you were gonna discuss this with the person who would know.
Yes, I needed to seek clarification from the zoning administrator.
And did you do that?
I don't recall the conversation, but yes.
And have you since learned whether or not the trampoline can or cannot be within the clear vision triangle?
Correct.
Okay.
Objection, Your Honor. That's called speculation. We haven't determined whether or not it's a violation of the clear vision triangle yet.
I just asked if.
I'll sustain and ask you to rephrase that. Strike that answer.
I have no further questions, Judge. I'll withdraw the question altogether.
Thank you. Questions?
Yeah, thank you, Your Honor. Afternoon, Ms. Hoover.
Good afternoon.
So at the time, like you said, you were an assistant, ordinance assistant.
Correct.
What's that entail?
At the time, I would take in any ordinance complaints and then put them on Julie's schedule for her to go out and inspect. And then depending on her findings, either close out the complaint or send a violation notice.
Okay, so that's why Officer Cordes emailed you, because she was following, according to this email, was asking questions about a potential ordinance violation.
Correct.
Regarding the clear vision triangle, because that's what it says in her email, correct?
Correct.
Okay. And your response was that you don't believe you regulate playscapes or trampolines.
Correct.
Because for permit purposes, is that what you testified to?
Correct.
Okay. But she didn't ask about permits for playscapes or trampolines.
She did not.
Okay. And you say that, you testified that you did speak to Lori about this 2 years ago?
I forwarded her the email and I don't recall the conversation that was had after.
Okay, so you don't know if you had a conversation after or not?
I believe we would have discussed it, but no, I'm not certain.
Further questions?
Anything else, Ms. Amon?
No, Judge.
You can step down. Thank you so much for coming. Call your next witness.
There's a people rest.
Okay? Mr. Lechner, witnesses?
That's a call, Officer Julie Cordes.
Okay. Good afternoon. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth. So help you God. Okay. You may proceed.
Afternoon, Officer Cordes.
Hello.
So you wrote Alicia Strong, ticket number 76086, is that correct?
I don't recall the ticket number, but I did write a ticket.
Fair enough.
This is the notice. That's the citation.
May I approach, Your Honor?
You may.
Okay.
Just for your own recollection, handing you with that. Do you know what that is? For purposes of, it hasn't been entered, Your Honor, it's for purposes of identification, we mark it as defense exhibit 3.
Okay.
Do you recognize that?
It has been marked.
It has not.
Well, let's do it. Mark it right now. John. I want you to get all these people in here. Is this the only witness or are you going to have another?
It's probably going to be the only witness, Your Honor.
Okay. Get all these people, lawyers, everybody, on these cases.
Okay. You recognize it's been marked for evidentiary purposes as exhibit 3 on the board?
Yes.
What is it?
It's a civil infraction for ordinance violations for the property that we're discussing at the Strong residence.
Okay. And you issued this citation?
I did.
Is that your signature at the, under complaint signature and receipt applicable?
Yes, sir.
Is that also your printed name under officer's name?
It is.
Okay. So you signed this case as a complainant?
Yes.
You're not the real complainant, are you?
No, that's been standard practice since I've been in this job, that I'm able to sign as a witness to the offense. So we're alerted to the offense, I respond, make my observations, and now I'm the witness to those offenses.
Is that the way you sign tickets all the time? Is that
Yes.
standard practice?
It's standard practice unless we have somebody that wants to specifically go on record and sign a ticket. And when we do that, it's rare.
Okay. Okay. Do you have other documents? Do you have defense exhibit 1 in front of you?
Is that the email?
Email, yes.
Yes.
So 2 years ago, you emailed Brittany Hooper about the Strong's trampoline in the Clear Vision Triangle. Is that correct?
Yep.
And you did that because Lisa Finn asked you if it's a violation of the township ordinance?
Yes.
Okay, well, I mean, that's what your email says, correct?
Right, I mean, it's some time ago, so I don't remember, the only reason I remember is because you placed it in front of me.
That's fine.
Yeah.
It's, I wouldn't expect, I wouldn't be able to tell you emails I sent 2 years
Right,
ago
right.
either, so. And Brittany Hoover responded to your email,
Yes,
and she said she doesn't know, she doesn't believe the township regulates playscapes or trampolines.
right,
So in that email, I'm sorry, was sent in, March 28th of 2023, is that correct?
Yep.
So, for over 2 years, the township hasn't addressed this issue or issued any violations, civil infractions regarding this trampoline.
not that I'm aware of.
Are you the only ordinance officer that will be writing such tickets?
Likely.
And now you have issued, you went out on the date in question and saw the trampoline and issued the violation, is that correct?
Yes,
So when you saw the trampoline, you could see through the trampoline, maybe not.
can I see you, exactly? No.
Yeah, you can't see through the trampoline. Do you have a plan to the one in front of you?
I have the construction, but I know what you're talking about. We can
So
go from-
there's a picture, there should be a picture of Mark P1, not on the back of
I don't have
it.
it.
May I approach your honor?
Yes.
Anything what's been marked as exhibit 1.
Thanks.
I don't know why I'm in here now.
Is this a picture of the trampoline, the Strong's trampoline?
Yes,
And it's not taken, how far away do you think, we'll strike that. Do you know who took that picture?
I believe I did.
Okay, great. How far away were you from the trampoline when you took the picture?
Looks to be about 20 feet, maybe 25 feet.
Okay. Can you see anything behind the trampoline?
Beyond it, yes.
Yes. What can you see, but directly behind the trampoline?
Well, I'm assuming it's a boat, it's under
Listen,
some plastic
guys,
wrap.
come on, please, listen, wait a minute. Ma'am, please. When you see your lawyer come in here, you come in, I'll get you out first. You gotta take the children out in the, I can't listen to that, please. I'm sorry. Go ahead, repeat your last question, will you?
Yes, sir. So, can you see what's directly behind the trampoline?
Yes,
What is it?
it's an object under white plastic.
Okay, so, but you can see that it's behind the trampoline.
Yep.
So the trampoline isn't obstructing your vision of whatever's behind it.
I guess that'd be subjective. There's things that it is obstructing that I can't see beyond it.
But you can see behind the trampoline, is my question.
Yeah,
Okay. You don't patrol the island looking for violations, is that correct?
there are some officer initiated stops that I would identify. If they're super obvious,
Okay, but as a general practice, you follow up complaints made by other residents of the island. Is
I
is
do.
that fair? Is that a
Yes.
fair statement?
Yeah.
And is it fair to say that you've been called out to either Strong's property or the Finn's property numerous times over the past few years?
yes,
Strong's made numerous complaints about barking dog. Do you remember those?
I do.
Okay. And you issued a ticket on that?
I don't recall.
You don't recall issuing a ticket?
Judge, I'm going to object this to relevance.
We know this is the Hatfields and McCoys going on, right? I don't know how much, I mean, I'll give you a little leeway.
It just briefly, Your Honor, Officer Porter testified that it's her general practice to sign complaints as a complaining witness. And she says that that's usually what she does. The ticket that she issued, she didn't sign as a complaining witness, even though she witnessed the dog bark and she was there when that happened.
Yeah, come on, move on, please.
All right,
Sustain.
no further questions.
Any questions, Ms. Anami?
No, Your Honor, thank you.
You can step down. Call your next witness. Mr. Lechner?
Yes, sir.
You have another,
We don't have any further, we don't have any more questions.
any, rebuttal?
No, Judge.
So I've not been fair to all these people, been waiting around. You guys go relax. I've got to go on. I got to get these lawyers out of here. And you can go outside, get your thoughts ready. Give me 20 minutes and I should be through these. Sorry. Rabria Caprice Bradford, 23T641127, A and B.
Good afternoon, Judge. Mazin Gates, I'm here on behalf of Ms. Bradford.
Come on up here, Ms. Bradford. Did you pre-try this case?
No. Right here at the podium. I'm the arraignment attorney. I thought she was.
Your name?
Bradford.
How many times do you think I'm gonna do this with you? I hope you got some money. I really do, because I am not giving you a personal bond again, okay? Not gonna do it. She didn't show up November 9 of 23, December 7 of 23, February 15 of 24. She posted a bond in May, it was supposed to be here in June and didn't show up.
Understood.
Why?
Judge, Miss Bradford has anxiety issues. All the courts that she's ever attended have been on Zoom. She's never missed one when it was on Zoom. Additionally, she has a newborn judge who was sick at the time and she wasn't able to appear. But she does have her boyfriend here now.
This case needs to leave before I'm dead, you know what I'm saying? I mean, come on. Why weren't you here?
She was having anxiety issues.
Pregnancy complications.
I'm not gonna reschedule this again. I'm gonna revoke this bond and set another bond. I'm just not gonna keep doing this. It's with Trenton. How many times am I supposed to reschedule a case?
Was Trenton here today?
No.
We could have pre-tried it.
Was Trenton here today? Lisa?
No, it's my understanding this was a warrant and she was here on a Judge Hessen case.
You had another case in front of Judge Hess.
She has.
Is that your child?
Yes, one of them, I have a 5-year-old too.
How many times do you think I should have to do this, really?
Judge, she apologizes. She's just, it's her anxiety.
Okay, you're telling through him? If it's truly that. Lisa, I'm setting it on the next Trenton docket. The very next Trenton docket that I have. When will that be?
June 26th at 2:30.
Ma'am, if you don't show up then, I'm revoking the bond.
Would the court allow her judge to appear via Zoom?
Do you know how to use Zoom?
Yes.
I don't care if she appeared. Did I ever tell you couldn't appear by Zoom?
Every paper just always say in person.
Well, maybe, just maybe, it's because you don't show up. Yes, she can appear by Zoom. Lisa, say she can appear by Zoom down there. You miss again. Yeah, I'm trying. June 26th at 2:30. I'll take her at her word, but that's it. Amanda Emerson, is she here, Ms. Emerson?
She's in Brownstown, Judge.
Amanda Christine Emerson, 24B146354, 24B146879, 25B147836. Tell them somebody called them. Tell me somebody called them. All right, good.
They're on there.
Your name, ma'am?
Amanda Emerson.
Appearance?
Good afternoon, Judge. I'm here on behalf of Ms. Emerson.
He's a fully current resident township now.
She didn't show up June 2nd, right? It's what happened?
June,
That she appeared intoxicated, Your Honor.
and the court put.
Why was she taken into custody?
She, yesterday, she was charged with trespassing at Tella Valley and assault and battery. She was arraigned down the hall.
With Judge Heston. Those cases have been set for trial.
Did you guys pre-try these?
There's no offer on, there was an offer prior. Ms. Emerson failed to appear on the 11th last week. So the prosecutor is not willing to offer anything.
Well, didn't we have a bench trial scheduled June 2nd?
We did, there was anticipation of, we anticipated a resolution, Judge, but that was the time that she came in. She was intoxicated, that was the time she blew a .17. So we set these out.
We're scheduled for final pretrial down the hall on the 25th.
I'm not adjourning this thing again.
I can respect that, Your Honor.
I mean, what is wrong with you, Ms. Emerson? What is wrong with you? I begged you to get into sobriety court 3-4 years ago. Begged you.
I have a day.
I don't want to hear it. Please don't say nothing.
Okay.
Please. I mean, these cases been going on. I don't even know what to do with her anymore. I'm throwing up my hands. I'm at wit's end. I really am. Other than just lock her up, set a bond she can't make. So remind me, she came in here June 2nd.
We were set for trial on that day, Judge.
Lisa,
Judge, I have a note on June 2nd that she was in the hospital, and that's how we adjourned to today.
Oh, that was the urgent care date then. So the one prior to that, she was intoxicated. Then June 2nd, her dad appeared with an urgent care letter.
Okay, right, I apologize, and yes,
was she in front of Judge Heston today too?
She was, Your Honor.
What happened over there?
It's been set for a jury trial, all matters, and she was given a $4,000 bond collectively.
When's the jury trial set for?
The jury trial is scheduled July 18th.
July 18th.
For the final pretrial on June 25th.
When she was picked up, was she drunk or high? Do you know, Detective?
I'm not aware, Your Honor. I don't believe so. I think she was on her way to the liquor store.
I don't know whether to be, I feel for you. You're ruining your life. You are the whopping old age of 36 years old, and you are ruining your life. You're not going to make 40. You're not going to make it to 40. I don't want to sound mean, weird, rude, anything else. I just don't know what to do with you anymore. There's nothing for me to do anymore. I'll do the same thing. I'll set a fire on a pretrial June 25th. Let's see, Lisa, let me think. Yeah, I guess I can do that in the morning, but I'd like her to come in here early. I mean, if you guys get a global resolution, fine, but I'd like to have her in here at 10, not at 2. You know what I mean? I'm not blaming anybody.
On what day, Judge?
On the 25th. She might still be in
I was gonna say,
custody.
Judge, I don't know that she can make the $4,000 bond, so she may still be in custody.
I know. I'm gonna need a jury trial date too, Lisa. These are all. So I'll set a final pretrial the 25th in the morning at 8:30. Is she gonna be, she's not gonna stay in Brownstown though. You guys are not gonna keep her there. You're taking her downtown, right?
Correct, Your Honor. She has a felony warrant with Wayne County as well.
She has a felony in Wayne County as well?
Yes.
I mean, I'm wondering if she doesn't have bigger fish to fry, if you know what I mean.
I wasn't aware of that.
I'm just saying, she's got another trespass, but I could care. June 25th at 8:30. Let's go about that. We'll figure out a jury trial date. You're not gonna be happy till you end up with the Department of Corrections. I can just tell. You can't wait to get there. I mean, you're doing your best. You cannot wait to get to the Department of Corrections. And if you think any other place that you've been has been surprising, that was like going to Hawaii. So keep it up. I mean, you're getting there. Give me a jury trial date, Lisa.
July 25th at 8:30.
July 25th at 8:30 will be the jury. I'm not going to adjourn it. I don't care what happens anymore. We're going to have her here. July 18th. Will you write all these dates down? I don't even know what to. I don't even know what to do. 5,000, 10% on her, on all of these files. 5,000, 10%. You can't go back. Did somebody not just tell me it was trespassing? Was it over at the same location area?
Yes, Your Honor. She has
Shocking.
two new cases.
Shocking. She's got 6 cases there. You can't enter 23601 Hickory Lane in Brownstown. No contact with Julie Fisher or prosecution witnesses. You cannot go back to 17874 Dennis in Brownstown. No contact with prosecution witnesses. You cannot go back to, I guess that might cover them. You cannot leave the state, cannot violate a law. You must appear in court as directed. You're going to have to post $1,500 to secure your release on your release on those 3 cases. I don't know what else to tell you. Thank you. Have a good day. Good luck. People against Kayla Linfeld, 25B82688C.
There's one more.
Is this Judge Hessens or is this Judge mine?
Both. I think there's 1, 2 in Judge
There's 2
Hudson.
with Judge Hudson. One is a dismissal, one is an adjournment, and the other one is yours. It will be an adjournment, Your Honor.
I have 25B82383C, 25B82688B and C, and I have 25B148713. So what are we doing here?
So we are adjourning.
Well, let's, first of all, she's never been arraigned on the June 2nd cases.
Stands mute, Your Honor, we are reading up the information.
These are Judge Hessens, right?
Yes, Judge.
So I'm entering a not guilty plea on those. Your name, Ms. Felton?
Kayla Felton. An attorney for you on behalf of Ms. Felton.
And then I've got another one from June 2nd, vicious act. She stands mute, waives formal reading.
Yes, Your Honor.
And then I've got another one from May 26th. It's mine.
And that's being adjourned.
Well, first of all, she stands mute, waives formal reading on that.
Yes, Judge.
So what are you doing on these cases? Adjourn for discovery on Judge Hessens. And you're nolly processing the dog at large case.
Correct, Your Honor. That was a duplicate ticket.
I see. What's it a duplicate of?
Of the June 2nd incident.
Whose Brownstown docket was this? Mine or?
Yours, for your matter.
So they did an
Okay.
emergency one, Your Honor.
Wait a minute. I wouldn't say a word right now. I read her brief. You're gonna have a comeuppance with me.
Okay.
You think you're gonna violate orders in this court from these judges, me or Judge Hessen, like you
No.
just did?
No, I'm saying,
I don't want you to say a word.
okay.
She tells you to do something and you take the dog and take it to Tennessee allegedly, or at least that's what you tell the police. Don't start with me. Don't say a word. You should not have said a word. And then you're acting back here, you're laughing, you got your kid fooling around. This is a big game to you, huh?
He's autistic.
I'm sorry about that. I really am. But you're still back there laughing with your friend. I'm telling you, you obviously don't think this is important or serious at all.
I laughed through pain, to be honest. Instead of crying,
I mean, I am really sorry about your son. I did not know that. And all right, give me a second here. PR. All right. I'm just kind of confused, to be honest. I guess when I read the brief, I must have misunderstood something. I got an A, B, and C of 688. We're adjourning all of those, right?
Correct, the two loose animal cases. Yeah.
Those are in front of Judge Hess, right? And then I've got 25B, 823, 83, A, B, and C that are in front of me. And you want me to dismiss which one?
The singular citation with dog at large. It was a standalone case.
Two five B 148713.
Hope so.
Okay, so I'm gonna go ahead and dismiss that one. That one is dismissed.
Thank you, Your Honor.
Now, where is the dog now?
It is in animal control custody. Ms. Felton did turn over the animal on Sunday night.
But I'm gonna go over this brief with you.
Yes, Your Honor.
This is what the prosecutor wrote. So, it's just been a long day. I'm sorry if I'm getting a little. Where's the brief on that? I had it here a second ago.
Do you want my copy, Your Honor?
No, I got it here. Yeah. So the Judge Hessen ordered her to turn over the animal to Brownstown Animal Control to be held at, this is after the June 2nd dog bite, right?
It was.
And she ordered her to turn it over to the animal control to be held at the owner's expense until the hearing is held. And you're saying defendant failed to do so. And then that was the second act. And these were bad bites of young children, right?
They were, yeah. The first incident was a bite. The second one was a bruising around a child's neck.
And then she advised animal control she drove the dog to Tennessee and gave the dog to someone she contacted over Facebook. But then she recanted on that and brought the dog in, right?
She did, Your Honor.
All right, so tell me exactly what you would like me to order in terms of bond. That the dog remain at the Brownstone Animal Shelter until further order of the court?
Yes, Your Honor.
Do I have a bond sheet here? Yes, I do. Do you have just one dog, ma'am?
I have two.
Where's the other one?
My house.
This first dog, can you describe the dog for me, Miss?
Animal control on that, and Your Honor, she's here.
Good afternoon, Your Honor.
Your name?
Kaylin Omnicra.
Okay, just let me make a note here. And Lisa, I'm just gonna write this one, and then I'm gonna ask you to fill this out. Go ahead. So what kind of a dog is that one?
It's a Siberian Husky Pit Mix. Black and white
Siberian Husky
Pit Mix.
Pit Mix.
Correct.
Fenced dogs remain in Brownstone Animal Shelter until further order of the court. Ma'am, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You're not to have any contact with any of the victims. You cannot write, phone, see, text, email, or communicate with them, or have anybody else do any of those things for you or on your behalf. That will be the bond conditions on all of these. And again, the dogs to remain at the Brownstone Animal Shelter, that's Siberian Husky pit mix, until further order of the court. We'll give you new dates on these. And Lisa, do you want to give me the dates? I'm going to have you write all this down. I got to get moving on these other cases. So what date?
July 16th at 10.
This will be July 15th at 10.
16th.
16th at 10. All right. Do you understand everything, ma'am? Yes. So I'm giving you a personal bond. I have to tell you, when I read these briefs, I wondered if that was appropriate. You cannot ignore orders of the court. Do you understand that?
I guess.
All right, let's let it go. You fill out a petition for court-appointed lawyer going forward. That will be the date. Lisa, just make sure you write that on all these so Judge Hesson knows what I did. Will you please?
Okay, hers are getting adjourned at the same day.
Yeah, we can do
Okay.
it the same day unless she's not here or whatever.
Okay.
Okay, thanks. Brooke, you're all set. Fill out your petition, go down the hall, get your notice. Thank you so much, counsel. You worked really hard today.
I still got one, if Mr.
Chantel Brooks?
No.
That's my
she's in
Thomas.
custody. It's
Chantel Marie Brooks. Where's Chantel Marie Brooks at?
She's in custody in Woodhaven, Judge.
Did somebody call 25W713-967? Good morning, detective. Your name?
Detective Kyle Davis, Woodhaven Police Department.
Raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you've given these proceedings will be the whole true self you got. Guys?
I do.
Okay, go ahead.
On June 17th, 2025 at 4:08 a.m., Woodhaven officers were dispatched to the BP gas station 25025 Allen Road for a report of a domestic assault that took place at 18642 Van Horn Road, apartment 6. The caller, the victim, Maya Wilder, advised that her and her ex-girlfriend, Chantel Brooks, have been having verbal and physical altercations off and on since Sunday, June 15th, and she wanted Brooks out of her apartment. Brooks did not live with her. They broke up 4 weeks ago, and Brooks was staying at her apartment since June 15th on Sunday. Wilder advised that the two had previously dated for 2 years and they have had physical domestic violence altercations in the past. Wilder stated that Brooks punched her approximately 8 times since Sunday the 15th and had continued to quote unquote put her hands on her. Wilder also stated that she had to defend herself on the 16th by punching Brooks while she was driving because Brooks threw pizza at her. Wilder stated that that was the only time that she had assaulted Brooks in defense. Wilder stated that she walked to the gas station on today's date, which was the 17th of June at approximately 4:08 hours, because Brooks had punched her in the right shoulder while they were arguing in the bathroom of the apartment. Wilder stated that Brooks punched her with a closed fist, but was unsure which hand that she had used. Wilder stated that after being punched, she went into the bathroom and called a friend, and at that time, Brooks came in and took Maya's phone from her. Wilder stated that she was not trying to call 911 at that time, but after she did not have a phone, that is when she walked to the gas station. Several minutes after that, Brooks opened the door and was once officers arrived to the apartment, but it took approximately an hour until Brooks was able to cooperate and she came out of the apartment where officers had placed Brooks under arrest for domestic assault. Later that day at 12:30 p.m., Maya drove herself to the Woodhaven Police Department, where I was able to get her in contact with the Wayne County Prosecution Office by phone. And it was there Maya disclosed that additional information involving her and defendant Chantel that occurred on the 15th, where Chantel was choking Maya, and Maya stated that she was unable to breathe for periods of times as she was trying to fight off Brooks. I collected that information and she added it to a supplement, and I included that into the report.
Based on your sworn testimony, I find that the crime of assault with intent to do great bodily harm less than murder by strangulation, as well as the crime of domestic violence were committed. There's probable cause to believe those crimes were committed by the defendant. When authorized the issuance of the complaint and warrant, you can bring the defendant out for arraignment.
Okay, just a moment. I'm gonna get her out of the cell.
Take your... It's been a long day.
Yes, it has.
All right. All right, ma'am, your name, please? Name?
My name is Chantel Brooks.
Good afternoon, Judge. Mazin Gates, on behalf of Ms. Brooks.
She's staying mute.
For arraignment purposes, we stand mute, reading, Judge.
Ma'am, I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a lawyer not only today, but at all subsequent court proceedings. And if you ever choose to submit the question with law enforcement officials, you do have the right to be represented by your lawyer at that questioning. You also have the right to a probable cause conference within 14 days and the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, the people have to show the crime was committed and that you were the one who probably committed the crime, and you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that? If they prove that, as to the felony count. Do you understand that?
Yes.
July 1 at 9:15 will be your probable cause conference. Preliminary exam will be July 8 at 11:15. Do you understand that?
So, I don't understand. What do it, so?
Okay, you're gonna have two
You said
courts. July 1st at 9:15 will be your first court date. That's the probable cause conference.
Oh, okay.
If it goes to a preliminary examination, that will be July 8 at 11:15. Okay, and that will be in front of Judge Hessen. Let's talk about bond.
Judge, we're asking for a personal bond in this matter.
Any objection to that?
No, Your Honor, course discretion.
I'm concerned about, I heard him say ongoing, and it took him an hour to get her out. So I'm gonna go ahead and give you a personal bond, ma'am, but I'm not gonna release you until you're fitted with a GPS tether. $25,000 personal bond. I hope they can do it quickly. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No contact with Maya Wilder or prosecution witnesses. You're not to enter 18642 Van Horn, apartment 6 in Woodhaven. You're not to possess firearms. You're not to possess dangerous weapons. You do have to obtain a tether. I'm not going to allow you to be released until fitted with a GPS tether. And you're not to be within 2 miles of the victim, her residence, or place of employment. Do you understand that? You can't go near her. Do you understand?
My truck, they didn't allow me to get my truck from there so I can make it home. Can I get like an escort?
Oh, yeah. I'll allow you one visit to obtain your own personal belongings, but you have to go with the police. So when you get on that GPS tether, you make sure you get a hold of the police and they'll meet you there. Okay?
Okay, thank you.
But don't go without the police.
No, you
officer.
can't.
Schedule the time and you meet them at the address.
And you mentioned that to the tether people, that the judge is going to let you go over and have the police meet you so you can get your personal belongings, okay?
Okay.
All right, any questions?
No.
Good luck.
Thank you,
Thanks,
Judge.
Detective. Thanks, Mr. Gate. Thank you very much, Ms. Patillo.
Welcome. I did have one more. Thompson, is he still in custody?
That one was at Wayne County and he never logged in.
Oh,
I'll have to reschedule it.
All right, thanks.
Thank you, you all have a good day.
Thank you very much, you too.
Thank you.
All right. Back on the record. And People versus Strong, 25I-76086. Okay. I am going to listen to whatever you two have to say for closings. Everybody's in order here. What would you like to say?
Judge, just very briefly, we have submitted memorandums of law that articulate the status of the law as it relates to statutory interpretation. I'm not going to spend a lot of time, but I do just want to reiterate that
Before you do that, I want to make clear, I've got plaintiff's exhibit number 2 up here, and I want to make sure I get all the exhibits. I don't have.
Oh, that's not.
So there's been exhibits admitted.
Judge, there was an exhibit that we admitted, which is plaintiff's exhibit number 1, having to do with the fence. We've since decided to not proceed with the fence and we'll write a ticket separately.
Fine. So plaintiff's 1, you no longer need me to look at.
Correct. So maybe we change plaintiff's exhibit 2 to number 1 because that's what we referred to it as.
I'll just refer to it as, you were referring to it as plaintiff's 1?
We were referring to it as plaintiff's 1 during testimony.
Mr. Lechner, do you agree with that?
Yes, Your Honor.
Put a sticker of plaintiff's 1 over that plaintiff's 2, and then I need your 2 defense exhibits, Mr. Lechner. I have defense 1 here, but I do not have.
I just gave your clerk defense too.
Okay. So I need defense 1, defense 2.
Do you have both?
Let me check. Here we go. That's difference 1 and.
He gave you defense 2, he said. Oh, this is it? Well, you gotta have these marked though.
It was marked, okay.
Yeah, but
I don't know, it was marked as the one exhibit was marked, I don't know if it's here, there's a number of exhibits here. Well, this is not marked. The one that I had, this is plaintiff's 1. I know, I gave them to your clerk to mark them, I don't know, it should be. Hold on, hold on right here.
you guys stipulated to the admission of this one that has shared with Lisa Pinn on March 27, 25?
Yes, sir.
That was what Ross Quero was testifying about.
I get it.
Questions.
I get it. The civil. All right. What's that?
It's been remarked plaintiff's 1.
All right, so I have plaintiff's 1, defense 1, and this one that just has, somebody wrote D2.
That's defense 2.
Yeah.
That's the.
Didn't we mark it though?
You did have a marked 1.
Oh, here's the marked one.
All right, yes. So I have plaintiff's 1, which was plaintiff's 2. I have defense 1, and I have defense 2. All right, so you guys are gonna go ahead and proceed with your argument.
Yes, Judge, I will rely on the memorandum of law that was submitted with all the case citations, but I do just want to articulate, Judge, that the ordinance is not ambiguous. Both case law and overwhelming case law dictates that the court is required to give deference to the township's interpretation of its own ordinances. The intent section of the ordinance itself lists preserve and maintain scenic views of the shoreline and further promote scenic views of the waterways. That the Ross Quero testified that generally, historically, it's always been applied that way. That's how the township has interpreted it. That's how he interprets it. And the purpose is to accommodate adjacent homeowners' views of waterfront properties. In this case, we had a complainant that complained that she was not able to enjoy the waterfront views due to this obstruction. In fact, the first sentence of the ordinance says, each lot shall maintain clear vision triangles along both side lot lines. Considering the township's intent with its regulations, we would ask the court to defer to the township's interpretation as is required under case law. I would also add, Judge, that where would it end, really? This is clear vision triangle. If the court is now going to say a percentage of transparency is allowed, then will the court come out and visit every time there's something in the clear vision triangle that's not landscaping? Will it depend on how transparent, if at all, the obstruction is? Where will it end? This is a trampoline, and if there were kids on that trampoline, nobody could dispute the fact that that would obstruct views. And certainly it's a trampoline intended for kids to play on, so there's going to be that obstruction. Judge, it's well settled law in Michigan that every day is a violation. And while there hasn't been testimony, there's been an implication that because of the delay in enforcement, we're precluded from enforcing. Frazier versus Haney, Judge, a case that came out just in February of 2022, it's 509 Mich 18. Statute of limitations doesn't apply because our ordinance, just like any other ordinance out there on municipal civil infraction, says every day is a violation, meaning yesterday was a violation, meaning today's a violation. So statute of limitations does not apply on code enforcement matters. Judge, we ask that in light of the testimony, in light of the law that we provided, that you find the defendant responsible for a violation of the clear vision triangle in section 285-17 4D.
Thank you. Mr. Luckman?
Thank you, Your Honor. I too would rely on my memorandum of law. I would say, I would dispute Tomami's statement. I think it's, first of all, a clear reading of the ordinance says, you know, you can't separate the two sentences. The first sentence says, don't violate the clear vision triangle. And then the second sentence says, as directed below, and it goes into the language of the trees. And it says, and further, it delves down even further, that the trees can't obstruct the view of the shoreline. The court went out there. Before that, we had two people testify today that you could see through the trampoline. You could see the boat behind the trampoline. Both Mr. Cuero and Officer Cortez testified that you could see through the trampoline. The court went out on June 2nd and reviewed it for itself, and you can see through the trampoline. It's not an obstruction. It doesn't obstruct vision. The township asked that their interpretation, their historical interpretation of the ordinance should be what the court gives deference to. No, the court should give deference to the words of the ordinance. First of all, there is no historical interpretation of the ordinance because Ross Cuero testified today that this is a case of first impression. No one has fought the clear vision triangle in this manner until now. They haven't had to write a ticket until now. This is the first time that this case has come into conflict. This ordinance has come into conflict in this court. So there is no historical interpretation. We're setting the historical interpretation today. If the township, in citing one of the township's own cases,
You mean the unpublished opinion?
No, Brandon Charter Township versus Tippett, Your Honor. And I'm paraphrasing. If Procedural Township did not intend to create this sort of interpretation in its ordinance, in its zoning ordinance, then the remedy is to amend the ordinance by going through the proper process. Procedural Township cannot attempt to enforce a zoning ordinance to reflect wording it wishes.
I don't know where you're reading from.
Okay, I'm reading from Brandon Charter Township, page 5. It's I can show you the case.
They're brief, right?
No, it's the case law that they cite. The people cite this case in their brief. They cite it specifically as to if a literal interpretation would cause would be absurd.
Is it page 5 of their brief?
No, sir. Page 5 of a case, Brandon Charter Township, which they cite in their brief.
Okay, hang on a second.
Specifically
Brandon,
from the case.
You're saying Brandon. Brandon,
Brandon Charter Township versus Tippett.
hang on,
It specifically cited,
slow down. I want to find it.
I'm on page 3 on your brief.
on page 3 on their brief, but and that's page 4
Okay.
in the,
Well, all that says, go ahead.
the case itself, it's not directly cited in their brief, but from the case that they're citing, and I'll read the exact quote.
Okay.
It says, if Brandon Charter Township did not intend to create this sort of reward in subsection 8.03.10 of its zoning ordinance, then the remedy is to amend the ordinance by going through the proper process. Brandon Township cannot attempt to enforce a zoning ordinance to reflect wording it wishes, their own emphasis, it had adopted that nonetheless does not appear anywhere in the ordinance.
Okay.
Ms. Strong shouldn't be taken to task for a poorly worded ordinance, which this is. There's ambiguity in the ordinance between the first section, the first paragraph sentence and the second sentence. It causes confusion. Never mind the fact it's not, the court saw it, you can see through it. It's not greenery fence, it's not shrubbery, it's not anything that is specified in the ordinance. So as such, we would ask that the court find Ms. Strong not responsible for this ordinance violation. And again, to address Ms. Hamame, where does it end? This is the first time this ordinance has been brought in front of this court, to my knowledge, specifically, as per Mr. Cuero's testimony earlier today. So I think the proper question isn't where does it end, it's where does it begin?
May I
Yes,
just
sure.
briefly, Judge? Judge, I take offense to the statement that it has never been interpreted. Every time you read an ordinance and you reach a conclusion, you're interpreting the ordinance. What Ross Cuero testified to was, we've never had to take it to court before because usually we explain our interpretation and the object is moved out of the clear vision triangle. So it has been interpreted, it just hasn't been decided by a court, except the unpublished opinion, which aids us in providing the intent of the ordinance, which is to accommodate adjacent homeowners' views of waterfront property, which comes out of that unpublished Court of Appeals case. As far as the ambiguity of the ordinance, the very first sentence says, each lot shall maintain clear vision triangles along both side lot lines between the average shoreline setback and the shoreline as described below. Shoreline as described below, which then has a figure which shows how to calculate the shoreline. Judge, that couldn't be any clearer. And if you interpreted it the way Mr. Lochner's asking you to interpret it, that first sentence is superfluous. There's no reason for it at all. And that's, the law says that if that's the case, then your interpretation can't be correct. You have to read every sentence in the ordinance. That's all, Judge. Thank you.
Thank you. Well, I actually would have liked to have done a written opinion on this because I find it very intriguing. We did go out there on June the 2nd. You and I, Ms. Hamame and Mr. Lechner, and I believe Ms. Strong was there. I don't believe the Pins were there. And we did conduct a site visit. There is a trampoline on the lot of the Strongs that could partially obscure the Pins' view of the waterfront property. And I don't disagree that the township's goal in enacting this ordinance was to ensure that people were not obstructing vision of the adjacent owner's view of the water in the clear vision triangles. Now, that trampoline does partially obstruct. But when you go back and look at this, and I'm going to quote it again, it's entitled Clear Vision Triangles. each lot shall maintain clear vision triangles along both side lot lines between the average shoreline setback and the shoreline as described below. As described below. And right below that, it says, within such clear vision triangles, the planting of a continuous row of shrubs, evergreen trees, or other vegetation that obscures views along the shorelines, i.e. hedgerow or green fence and pairs, shall not be permitted. Now, I do not wish to criticize anybody, but let me just put it this way. If the intent was to prohibit the placement of any temporary object that would obscure vision along the clear vision triangles, the township ordinance, the township board could have and should have made it much more clear in their language. They could have easily said, included language where we're not left to guesswork as to whether or not this is just vegetation. And it's ironic, I thought, because the case that you cited, Ms. Amami, was involving landscaping. It didn't involve any temporary object. I think it's been clear here. You want to apply for a permit for a shed or other things, you have to apply for the permit, no matter where it is. But when I read this, and I read it over and over and over, as described below are the operative words. And then it goes on, within such clear vision triangles, the planting of a continuous row of shrubs, evergreen trees, or other vegetation that obscures views along the shoreline. So what they're saying is planting a continuous row of shrubs, a continuous row of evergreen trees, or a continuous row of vegetation that obscures views along the shoreline shall not be permitted. It doesn't say anything about prohibiting temporary objects, movable objects in the clear vision triangle. I'm sure everybody would love to have an unobstructed view, but that isn't what this ordinance said. It specifically talks about landscaping, and again, that's what you mentioned in your the case that you cited that was unpublished. I agree with Mr. Lechner here. And again, I cannot emphasize enough, if they wanted to include other items, they should have, and if they still do, they can amend their ordinance. I'm finding defendant not responsible. Thank you.
I'm not trying to minimize the activities he did on probation. Judge, I would ask, since he served basically 92 days out of a year, what I would ask this court to do